Hi, everyone. Thank you for joining me today. What we'll be discussing is the 5 biggest estate planning mistakes and how to avoid them. Also, welcome to our Facebook Live audience. So for those of you who are joining me today, if you stay till the end, we will have a gift for you at the end. So please stay tuned. I'm Lynn St. I am the founder of Elder Law Group, ELG estate planning lawyer. So as I mentioned, we are talking about the 5 biggest estate planning mistakes and how to avoid them. What we're going to be talking about are some of the most common mistakes that I have seen here in my estate planning law practice here in Spokane, Washington. First off, though, I want to say that we're going to assume that you have an estate plan. It pretty much goes without saying that if you don't have an estate plan, well, you need one. If you haven't taken the time to put an estate plan in place, well, you're with a lot of good company. They haven't done so. But we do recommend that you do put an estate plan in place, one that's right for you, one that avoids all the mistakes that we're going to be talking about. One of the things that people don't realize is that if they don't have an estate plan that they've created on their own, well, they do have an estate plan. It's just one that was created by the government for them, and it's probably not the one that you want. So an estate plan, we're going to assume that you have one. All right, let's get to it. Mistake number 1, not designating accounts to pay to your intended beneficiaries. So a key purpose of an estate plan is to make sure that your assets go where you want them to go, to the people that you want to receive your assets. Estate plans can do a lot of other things, include protecting you from taxes and losses, etc. More about that later. But the mistake that people make is not understanding their assets and understanding what they need to do to direct their assets. Now, why is that? The reason for that is that people think that their will covers all their assets. Wrong. Your will does not cover all of your assets. What a will doesn't cover, what a will doesn't address, are what we call non-probate assets. That would include like your IRA, your 401k, your annuities, your life insurance policies. All of those are considered non-probate assets. And when it says non-probate assets, what that means is that your will doesn't cover those assets. When I say it doesn't cover it, that means your will is not going to direct where those assets go. Those assets need to pay by way of a beneficiary designation form. That is a form that you fill out with your financial advisor or with the financial institution that holds the asset. So a lot of times people just overlook it. They don't think about those assets, and then they don't address them. And that's where the problem comes in. So if you have, for example, a do-it-yourself form, an online form for your will, you probably just fill that out. You may even follow the formalities of having it notarized so that it actually is a valid will, but it's not going to cover perhaps your biggest asset, your IRA, for example. You're not going to know that. You're not going to know that because you haven't met with an attorney that's described and explained this to you. The forms aren't going to help you do that. So one of the things that's really important to understand is that certain of your assets must have a beneficiary designation form completed correctly, filled out, and with a financial institution. And that way you can ensure that that asset goes where you want it to go. So let me give you a couple of examples of things gone wrong. This is a situation where I actually did a probate for this gentleman after his death. His will, which was completed by another attorney, and this attorney was not an estate planning attorney, said, I want my retirement account to pay to the trust for my grandkids. And this gentleman's retirement account was his biggest asset. He was in his 70s and he had recently married. Well, unbeknownst to him And the attorney, who was, again, not an estate planning lawyer, a general practitioner, who had prepared his will for him, they didn't talk about the need to change his beneficiary designation. So what happened? Well, his retirement account was a 403B. It was with TIAA Pref. And what happened was the document that plan itself said that on the death of the account holder, it would pay to any spouse. He had just gotten married 2 years before his death. He'd accrued all of this money over many, many, many years. But because of what the plan said, and because he didn't understand this asset and his lawyer did not help him out, what happened was when he died, the biggest asset of his estate went to his brand new wife and not to his grandkids. Not at all what he wanted. So that is really one of those examples of, what can go wrong. It went wrong for him. Another example, let's say that you have a 401k and that you get a divorce. And before you were divorced, your 401k said, hey, it pays to my ex-spouse, or to my spouse at the time. After your divorce, it's your ex-spouse. Let's say you change your will and you say, ex-spouse, you get nothing. But you didn't think to change the beneficiary designation on the 401k. It still is paying to that person who is now your ex-spouse. And again, it can be your biggest asset. What happens? When that person dies, the 401k will pay to the ex-spouse, regardless of what the will says, regardless of the fact that this person absolutely would not want the 401k to pay to the ex-spouse, but because the person didn't change the beneficiary designation, that's the outcome. So there can be some really serious consequences that happen in somebody's estate planning if they don't take care of their beneficiary designation. So what should you do? Number one, you should talk to an estate planning lawyer. That example I gave you about the gentleman whose grandkids got nothing, he had his will done by a general practitioner. If you talk to just about any lawyer, they'll say, I can do your will, because they're not thinking. They think the will is just this simple document. They're not thinking about the estate plan and all the complexities and something, what an estate planner would think of. That's why there was such a bad result with that gentleman whose grandkids got nothing. You should also talk to your financial advisor in the financial institution that holds your assets, because the financial institution, they're the ones that have the forms that you need to complete. And I have to tell you, forms at every financial institution, they're all going to be completely different. So you're going to need to say, I need help filling out those forms in a way that the financial institution will accept. The lawyer can give you guidance to say, you want it to pay to your spouse, you want it to pay to the trust for your spouse, you want to pay to the kids, whatever, but you do need to fill out those forms. And if you don't fill out the forms, that account is not going to pay where you want it to pay to, and that's going to frustrate where your estate plan is. Mistake number 2, not properly funding your trust. So what we're going to talk about now are revocable living trusts, and these are commonly promoted, especially by financial advisors, on a nationwide basis. What's important to understand is that trusts are not one size fits all. No estate plan is. And whether a revocable living trust is right for you is really dependent upon what your circumstances are. In Washington, where I practice, oftentimes we will not recommend a revocable living trust, and that's for a couple of reasons. One of the reasons may be that in Washington, the only way for you to protect assets for your spouse when you're gone against long-term care expenses in the state is if you create this special kind of trust through your will and not through a revocable living trust. And that's a topic for another day. But that's one of the reasons not to do a revocable living trust in Washington. Another reason not to do a revocable living trust in Washington is our probates are so simple here. So a revocable living trust, the primary purpose of it is to avoid a probate. And I'm sure we've all heard that probates are bad and to be avoided. We'll talk a little bit more about that. So first of all, let's talk about, well, the mistake with revocable living trust. And let's assume that the revocable living trust is the right estate plan for you. So what goes wrong? What goes wrong is that people don't fund the trust. In order for a revocable living trust to work and do what it's supposed to, assets have to be in that trust. So for example, your bank account must be retitled in the name of the trust. Your house too. So let's say you and your spouse create a revocable living trust. Your names will be on all those assets. Well, you have to change the names on those assets. You have to change it now to you and your spouse as trustee. You have to do a quit claim deed on your house to change it from your name and your spouse's name to you as trustee and your spouse as trustee. And oftentimes that doesn't happen. The trust doesn't get funded. And if the trust doesn't get funded, then the trust isn't working like it's supposed to work. It's not managing those assets. One of the reasons that people don't understand this is that, this trust, it's like a separate legal entity, yet it's not. I mean, the assets need to be titled in the name of the trustee of this trust, but the trustees, they don't have to do a tax return. They don't have to get its own tax number. They're just, and frankly, they don't understand how a trust works because it's kind of esoteric. How does a trust work? So that's one of the reasons that trusts don't work. The main reason is because they don't get funded because people don't understand that they have to fund them. So even though the idea is that a trust is supposed to simplify your estate plan, it can paradoxically make it more complicated. A trust is supposed to help you avoid a probate, but if you haven't funded the trust, you will not avoid probate. You're going to have a trust administration and a probate. So with a lot of estate planning problems, the reason that they don't work correctly is people do it-yourself forms, or people buy, online forms and get like an hour consultation from somebody who may or may not be a lawyer, and they're just not going to take the time to explain all the things that you need to understand. So with a lot of things, getting good estate planning counsel is going to go a long way to make sure that you don't run into these problems. So let me give you a couple of examples of revocable living trusts gone wrong. So here is another single gentleman, and somebody recommended for him, and he got a revocable living trust. Now, he was a single man, he had no children, but he had lots of nieces and nephews. I think it was 18 nieces and nephews. So for him, avoiding probate would make sense because, see, when you're doing a probate, the will is filed with a court, and then the executor needs to give notice of the fact that there is a probate to what are called the heirs at law. And so for this gentleman, his heirs at law were his 18 nieces and nephews. So that's a lot of work. And especially in this case, it wasn't what he wanted because he just wanted his one favored nephew to get his house and his bank account. So a revocable living trust would have made a lot of sense. But you can kind of guess what happened here is that neither the bank account nor the house were put into this trust. So the trust had no effect. So his estate did need to go to probate, and we did need to notify the 18 nieces and nephews that the one favored nephew was going to get it all. So I really can't tell you why a revocable living trust was recommended to this gentleman. Maybe it was on the relatively inexpensive side, that being, $500 to $2,500, and somebody said, hey, this is a great idea. I know that had he come to us and had we done his estate plan, it would have been very simple. We would have recommended that he have his one bank account pay on death to the nephew, and we would have recommended that his house do a similar thing. Not go through probate, not be put in a trust, but do what's called a transfer on death deed. And if you record a transfer on death deed before his death, then on his death, his house would have gone virtually automatically to that nephew. And there would have been no estate administration, no trust administration, no probate. It would have been very, very simple. So sometimes what we do as estate planning lawyers is we do avoid probate because there's no benefit to a probate. And this is a good example of no benefit to either a trust or a probate. Yeah, basically a revocable living trust was not the right thing for him. All right, mistake number 3, choosing the wrong executor or the wrong trustee. So when you're thinking of choosing an executor for your will, an executor, or who that is, that's the person who carries out and implements your wishes under the will. When you're thinking about who to choose, sometimes people think, well, I'll choose my spouse, or I'll choose my kids, or some other family member, sibling. And that can be a fine choice. It's not dependent upon the relationship so much, though it is important if somebody knows you. But really what is critical is that that person is capable. They're trustworthy. They will do their job. They have a business orientation. They're organized. They're somebody who will take their job seriously and get it done in a timely manner. So when you're thinking about who to select to be your executor, or who to select to be, if you have a revocable living trust, who to select to be your successor trustee, that's the trustee after you who'll carry out your wishes once you're gone. What you're really looking at is ideally they are a family member, they know you well, they're trustworthy, but more than that, they are capable. And if you don't have that type of person in your family, then you probably should consider nominating somebody who is a professional, because there are professionals, they're called fiduciaries, and they will get the job done, they'll do it well, and yes, they will charge a fee. That's one of the reasons people sometimes are reluctant to name a professional, but I got to tell you, getting the job done in an efficient manner is going to save a lot of money, even in light of the fact that you're going to have to pay that professional to do their job. So here's an example. A gentleman named his wife to be the executor of his will. That makes sense. Under his will, his wife would get certain assets, and his children from a prior marriage would get certain assets. And what happened was the wife chose not to do the probate, chose not to file the will with the court, basically chose to do nothing. And by doing nothing, and she's on title to certain accounts, and she's on title to the house, she can just continue living her life as if the husband, hadn't said in his will that certain of assets are supposed to go to his kids from the prior marriage. So that probably wasn't the best choice of the executor, because his wishes are not being carried out. His kids and his grandkids are not getting what the will said that they should get. And the reason for that is that the wife just went along and didn't implement the will through the probate. I guess I would put it on the kids too, the people that have a copy of the will and they know that they're supposed to get things. It really also is incumbent on them to say, hey, a probate needs to be filed because, grandpa wanted these kids to have money for their education, and that hasn't happened. By selecting the right executor, then that situation wouldn't have occurred. Let me talk a little bit about probates and why they have such a bad name. Probates have a bad name because of what you hear in the media. What comes to light are those situations that are terrible situations. Number one, it was a bad estate plan. Or number two, it was a bad will or no will. I had a very crazy probate involving Kitty Oaks here in Spokane County. And one of the reasons it was such a terrible probate is there was no will. And because there was no will, and there's a lot of other things that added into it, the attorney's fees were quite high. There was 4 attorneys involved. All of that could have been solved easily had there been a will, which there wasn't. So probates are given a bad name because you hear about those. You hear about the high costs. With a situation with a good estate plan, a probate can be a very efficient process to an orderly administration of the estate. Yes, it's going to cost money. You can try doing it, a do-it-yourself probate, but I can tell you that it's very rules-driven based. You do this, you do that, you give notices, you do this, you do that. And if you're trying to do it yourself, the likelihood is you're not going to get very far. A lawyer who's done many of these is going to be able to do it quite efficiently. However, whenever you're talking about legal fees, you're talking, legal fees will easily run in a probate $3,000 to $10,000 to give you a sense. That's in Washington State. In California, it's based on a percentage of the estate, and that's why people in California want revocable living trusts. Here, though, in Washington, probates will cost money, but sometimes it's a really good idea to do a probate. One of the things about probate, too, I wanted to mention is that if you want to protect assets for your spouse when you're gone against long-term care costs, the only way our state allows you to do it is if you have a will, you probate it, and a trust is created through the probate for your spouse. Again, that's a topic for another day. With revocable living trusts, people are not likely to even seek out legal counsel. And so what that means is that the trustee who's trying to carry out the terms of the trust, once the trustor is gone, is deceased, they may do it right, they may not do it right. And so the result of that will be there could be litigation that arises from revocable living trust. Just because there's a revocable living trust doesn't mean there's not a forum for somebody who's aggrieved by the successor trustee and what they're doing. They certainly can file a lawsuit. So a revocable living trust by no means guarantees that there won't be a fight and angst and legal costs. It all depends on how good was the estate plan? Was it set up right? Did you select the right person to carry out your wishes? Mistake number 4, allowing joint owners on assets like bank accounts. So this is another common estate planning mistake that we often see. And that is, for whatever reason, kids' names may be put on bank accounts. So a lot of the time when we see that happen, it's because the person said, I just wanted to make my estate plan easier. I just wanted to avoid a probate. It just made sense to them to put somebody else's name on their bank account. And that way, when they die, then the joint owner becomes the owner of that bank account. Well, what happens if, let's say, mom puts, she has 3 kids and she puts all their names on her bank account? What that does is that just opened up that bank account to creditors. Because if any of these 3 kids, and let's say that they're good kids, but everybody makes mistakes. If the kid is subject to a divorce, or maybe there's a creditor's claim against them, or maybe they caused an accident, auto accidents happen, somebody sues the kid, that bank account is now subject to the creditor's claims. And so it's subject to potential loss of that account. So it's really not a good idea to put anybody else's name on your bank accounts. So let's say that for whatever reason, we are avoiding probate for mom and everything's going to pay equally to the 3 kids. Then all you do is say, kids are not on the bank account while mom's alive, but there is a form that you fill out at the bank. It's called pay on death or transfer on death. And you say, pay on death to, and you name your 1, 2, 3 kids, and on the death, then the 3 kids equally get that bank account. So that's a better way than adding the kids as joint owners on the accounts. Sometimes rather than naming all 3 kids and putting them on the account, what happens is the person says, I will just put Sally on the account, and she's going to be my executor anyway. And she'll make sure that after I'm gone, that her 2 siblings get their share of this account. Maybe, and maybe not. If there's just one joint owner on the account after the parent dies, that joint owner, the survivor, that kid, Sally, now owns 100% of the account. And then it's up to Sally to say, okay, I will divide it with the rest of you, because that's really what our parent wanted, Or Sally might say, you know what, I was always the favorite. I was always mom and dad's favorite, so I get to keep the money. And believe me, that happens, and that results in litigation too. So that's another reason, another mistake. Don't put joint owners on your assets. It's really a bad idea. I do want to talk a little bit about giving away assets. You know, this is along the realms of people thinking, you know, if I just do these certain things, I'll be able to avoid a probate, make things easier when I'm gone. So sometimes what they do is they think, well, I'm just going to give away my assets. Giving away assets can be okay, but only if it is done as part of a SMART plan. So when it comes to giving away assets, first thing I want somebody to think about is, can you afford to give away your assets? Certainly people who are very wealthy and subject to, estate tax, they give away their assets. Likely they're doing it as part of a tax plan. What a lot of people don't realize is that you can give away $11 million and pay no tax on that giveaway. And the recipient of the $11 million pays no gift tax either. They do have to file a gift tax return with the IRS to say that they've done that, but there's no gift tax. You might have heard of the annual exclusion gifting amount. That's $15,000 a year to unlimited number of people. At least that's what the current law is. There is no requirement of even mentioning it to the IRS that you gave away $15,000 to 10 people. That's allowed. So there's a lot of ways that people with wealth can bring down their estate level, to avoid estate tax. Really, the more of the concern for people who are not wealthy is that they give away an asset, and as a result, there is going to be a capital gains tax. Capital gains tax is something that people simply don't think about. They might think, well, I'm going to be facing long-term care costs, and I want to protect my house, or I want to protect the lake cabin, so I want to give it away to my kids. If they do that, then the kids will receive the house with what's called a carryover basis. This is a tax concept, and I don't want to get too bogged down in it. But what it's important to understand is, well, maybe I'll give you an example. Maybe that's the best way to explain it. If you give away a house during your lifetime, or your cabin, or whatever, whomever you give it to gets it with the basis that is your basis. So let's say you bought the house or the cabin for $10,000, and when you give it away, it's worth $260,000 or something like that. The kid gets it at a $10,000 basis. So if they later sell it, they're going to pay capital gains on $250,000. That's what, $37,500. Whereas if they had inherited it when they receive it, they get this adjusted step up in basis, and when they sell it, then they'll pay zero capital gains. So I'm not expecting everybody to go, oh God, Lynn, you're doing math, this is getting way too complicated. I don't want you to have get this down like you're a tax accountant, you're a CPA. What I just simply want you to understand is that there are consequences for you giving away assets during your lifetime. And before you do that, see an elder law and estate planning lawyer, because it's not just the tax issues like we talked about, it's also the Medicaid issues. Medicaid has a 5-year look back. And if you give away assets within 5 years of actually needing and applying for Medicaid benefits, there are some serious consequences. Penalty periods, there's 150% penalty if the state has to pay for your care because you couldn't get the assets back from your kids. So what people attempt to do to simplify things sometimes makes it way more complicated. So what I tell clients is, don't give away your assets, keep your assets, unless you give them away and you understand the consequences and it's done as a part of a SMART estate plan. All right, let me see if there are, before we get to questions and answers, we are going to be giving away a free gift. And so for the Facebook Live audience, please write this down because it won't be in the chat, you won't see it. If you want a copy of your guide to estate planning, just send an email to webinar elgwa.com. Send us an email and we'll send you a copy of the gift. All right, so here's some questions. What was that again, the transfer on death? Okay, great question. There is something called a transfer on death deed. And what that deed does is it says on your death, let's say the house is we're talking about. The house has a transfer on death deed. The house will go to whomever you said it should go to. So let's say you're a single person, you have 2 kids, they get along great. On your death, you want the kids to get your house, but you want to avoid a probate. You want to avoid, because there's no benefit to a probate. So we will avoid the probate by doing a transfer on death deed. It is a great mechanism, a great tool to avoid a probate when a probate doesn't make any sense. Think of the transfer on death deed kind of like you would, like your life insurance. You know, it has a beneficiary designation. It pays to your 2 kids, for example, or your bank account pays on death to your 2 kids. You can do the same thing with your house, but you need to do it through a transfer on death deed. And it has to be recorded with the county before your death. But it is a great estate planning tool. Next, if a valid will exists, is it legal for the wife to ignore it? No, it's not legal for the wife to ignore it. But the problem is who's going to enforce it? So in the state of Washington, the person in possession of an original will must file it within 40 days with the court, but they don't have to start a probate. They're supposed to start the probate, but they don't. Maybe they don't know, or maybe they just don't want to. It's really going to be incumbent on the other people who are the beneficiaries of the will to take some action and follow up. And in that case, I would recommend the other beneficiaries of the will to hire a lawyer to help them, because somebody's not doing their job and they're going to have to be forced to do their job. I am just going to go over all the 5 mistakes because, sorry, I don't remember that if I said all of them. So let's just go through this, make sure we've talked about them all. Number 1 is not designating beneficiaries on your accounts. Number 2 is not properly funding your revocable living trust. Number 3 is choosing the wrong executor or trustee. Number 4 is allowing joint owner of assets and accounts. Number 5 is kind of what I confused. Number 5 was giving away assets. I talked about it, but I don't think I actually said. Number 5 is giving away assets without a good estate plan.